This is for Italian lecturers in the UK. 5 minutes, please, for your petition. Thank you.
Good afternoon. First of all, my thanks to you, Madam President, for granting us this hearing. My very warm thanks also to the Secretariat of the committee, who have always treated us with great courtesy and have provided continuity over the last 27 years. Madam President, I will begin, perhaps unorthodoxly, by asking a question. Does the committee see circumstances in which a member state may be justified in suspending, by decree law, the obligation to uphold the EU treaty, and in particular, Articles 47 and 21 of the EU Charter on Fundamental Rights? Some background. Italy has been found to be in breach of EU single market rules that prohibit discrimination based on nationality in 6 judgments in the European Court of Justice. The Italian state should have fully implemented the judgments of the courts, but to date has not done so. Up to 260 non-Italian lecturers are still currently in court suing for arrears on their wages and pension contributions. The last decade. In 2011, the Commission opened an EU pilot case aimed at resolving the problem quickly and in a friendly manner. The so-called Gelmini law, which I warned the Petitions Committee about in my speech in January 2011, had a clause that extinguished pending court cases. This resulted in many of my colleagues having their cases automatically terminated in the domestic courts. Not until 2 August 2017 was this practice deemed illegitimate, when the Court of Cassation said, in essence, that cases pending could only be automatically terminated if they favoured the plaintiff lecturers. Italy introduced further norms, Article 11 of Law 167 of 2017, and an interministerial decree law 765 of 16 August 2019, which purports to put into effect Article 11 and to fulfil Italy's obligations to the EU by means of a supplementary contract to be co-funded by the state and the universities. However, this decree contains a clause asking us to sign a declaration renouncing, and I quote, renouncing all the acts and or any and all legal action already pending and or to be instituted in merit and or executive. It's document 1 in your files. That is to say, we are asked to renounce all legal protection as European citizens under Article 47 of the Charter of Fundamental Rights. Madam President, your predecessor, Mrs. Cecilia Wikström, on 23 January 2018, sent our petition to the Parliament's Brexit Steering Committee, chaired by Guy Verhofstadt. That, if I may say so, Madam President, was rather prescient of Mrs. Wikström and the Petitions Committee, given the current debate on international obligations. I should point out also that the 260 contain lecturers from all over the European Union, although, of course, because of English, Britain seems to be the largest number. Finally, I have a question for the European Commission. The ECJ has found on 2 occasions that Italy had failed to uphold its treaty obligations in the foreign lecturers' cases. We fear the Commission has thrown in the towel. My question: what measures can and will the Commission take before I join the substantial number of my EU colleagues who are already in their graves? Thank you, Madam President.
Thank you, Chair, and thanks to the petitioner. I would like to provide the Committee of Petition an update with regard to this outstanding issue raised by the petitioner. I will focus on the question related to Article 47 of the EU Charter of Fundamental Rights, and my colleagues from DG Employment will deal with the question concerning the compliance with the judgments of the European Court of Justice. The first issue raised by the petitioner concerned indeed the last indent of Article 26, paragraph 3 of the so-called Giovannini law, which provides for the closing of all cases concerning the economic treatment of the lettori pending before the national court at the moment of the entry into force of such law following the intervention of the national legislator. As explained in the previous communication, the Commission, following an inquiry by its services on how the contested provision was being applied in practice, entered into a dialogue with the Italian authorities with a view to finding a solution of this issue. The Commission recalled that as a result of this dialogue, the Italian authorities informed the Commission about the adoption of Article 11 of Law 167 of 2017, and the stated aim of such provision, which entered into force on 12 December 2017, is to allocate the fund necessary to allow the university concerned by the cases still pending before the national courts to abide with their obligation towards the lettori, so to ensure that the effective enforcement of the provision introduced by the Italian legislator are in line with the economic treatment of the lettori, in line with the requirements of Article 47 of the Treaty of the Functioning of the European Union as interpreted by the Court of Justice of the European Union. As regards the implementation of Article 11, which the Commission committed to fully monitor, the Commission would like to inform the committee that following a new request of information, the Italian authorities, by letter of 12 November 2018, communicated that an implementing decree was being adopted by the Ministry of Education and Research. By letter of 9 January 2019, the Ministry sent to the Commission the draft implementing decree, and on 30 October 2019, the Italian authority notified to the Commission the adoption of such decree 765/2019, which implements the law and provide for the allocation of monetary amounts to the university concerned, defined the criteria for the allocation, and included a standard template for the supplementary collective agreement to be signed by the university and the former lettori by 31st October 2019. This deadline was subsequently postponed by the Italian authorities and was scheduled to expire on 30 June 2020. With regard to the pending proceedings to which the former lettori are party, Article 8 of the implementing decree provided the entry into force of the agreements with the university is conditional upon the waiver of the procedure pending before the National Court. By note of 13 February 2020, in response to the Commission Services request for additional clarification, the Italian authorities clarified that each former lettori has a choice to either proceed with the judicial proceedings or sign the agreement with the university, which follows the collective agreements concluded by the trade unions with the university. Only if that agreement is signed and the former lettori expressly waive the pending action, the parallel proceeding is terminated and the demand must be considered satisfied. It is the Commission understanding that the effect of the legislative framework composed by Law 240/2010 and Law 167 of 2017 as implemented by the Decree of 2019 is that the pending proceedings are not automatically terminated. In addition, a conciliation procedure for the signature of the agreement with the university is at the disposal of the former lettori. By note of 5 August 2020, in response to the Commission Services request for additional clarification, Italian authorities reported that only very few universities concluded the collective agreement with the lettori. As this matter is linked with the implementation of the judgment of the European Court of Justice, I'm giving the floor to my colleagues in DG Employment to deal with the second part of the reply to this petition.
As my colleague Alessia has said, the Commission, the number of universities that have concluded the necessary collective agreements is very small, and the Commission had hoped that these two legislative provisions, the law and the decree, would have put an end to the disputes, to the ongoing disputes. However, the Commission has noted that there is a low number of universities that have concluded the agreements, and therefore the Commission is going to contact during this week the Italian authorities to see the way forward, how we can put an end to all these disputes, which come from the fact that neither the judgment of the Court of Justice nor the Italian law, I think, they provide for a concrete method of calculation of the reconstruction of the career of the lettori. Thank you very much.
Now I'm giving the floor to Mr. Cosa.
Thank you. So
I'm going to speak about this petition. This is to do with people that work speaking languages in universities. That they get paid a terrible salary. This is not a new issue. There have been 5 different petitions here. And this is something that the Commission has been following for quite a long time, trying to get round Italian bureaucracy and trying to come to a...
the Commission has been following this case since 2004.
In 2018, the Italian ministry proposed this decree setting up the possibility of having a framework with fair conditions for these people, for these cases, providing for a legal solution to the status of these people. However, as has come to light since, as the Commission has been told, this new decree was imposed by June 2020. So when that time came around, the University of Milan wasn't involved in any of these new collective bargaining agreements. The Fundamental Treaty, the European treaties prohibit discrimination on the basis of nationality in all contexts. That's a fundamental principle of the European Charter of Fundamental Human Rights. That's Article 21. And it's quite clear here, I think, that the authorities didn't even adhere to their own domestic legislation. And this petition constitutes administrative discrimination. So we should keep the petition open and call upon the European Commission to institute all legal measures necessary against the Italian authorities, and for that to stay open until it's resolved. That's what the EPP would like to see.
Thank you very much. Now has the floor Aju Saliba.
So again, thanks for the petitioner for being here today and also explaining again for another time in front of this committee his petition, his request. And also concerning the evolution of the above-mentioned petitions after also the last Commission reply, which we received on March 2019, an infringement procedure has been initiated by the Commission on these very serious issues and practices being undertaken by Italian universities. The Italian government has reacted with an interministerial decree, Decree number 765 of 16th August 2019, which basically allocated the sum of 8,705,000 to increase the ordinary fund for universities. And this is established also under Article 11 of the same decree. The fund will be distributed among universities that basically they have adapted a consistent supplementary contract coherent with the following two criteria. Again, I'm going to quote the same decree. The sum will be distributed among the universities in proportion to the number of former lecturers in service as at 31st December 2018, with reference to universities that have adopted a supplementary contract by 31st October 2019. The remuneration must also correspond to that of a confirmed researcher on a fixed term basis and proportional to the hourly commitment made. The full commitment must correspond to 500 hours. In light of the above, I think that Italy is taking action at least to regulate the position of foreign language lecturers. But at the same time, I think that it's important to leave this petition open so that the Commission and also the Petty Committee could continue to monitor at least whether the Italian universities are complying with this decree and also if they are utilizing the fund that has been moved forward by the Italian government in accordance with, again, this ministerial decree. Therefore, thanks again for this petitioner and for this petition, and also I reiterate my point to leave this petition open for now.
Thank you very much. This is about discriminatory treatment of foreign language assistants in Italy, and these are old cases. I would like to thank the petitioner for fighting for this for a long time and for not giving up. I think that the thing is that we have been following this for quite a long time, and there are other cases relating to discrimination in universities in Italy. There are a Spanish petition and a German petition. The European Court has decided in several cases that Italy is infringing the law. There is no compensation for unfair treatment. This is about the fate of the lecturers. Many of them are already retired, but there is also the case of it is also about the rule of law, because Italy is not respecting court decisions. And I think that we need to see what is in the treaties. All member states need to stick to European law. And we would like to support the petitioners on this. This is about a different sector, a different field. I think that this is quite similar to the previous petition, though I find it difficult to see actually how we can have been having this case and this petition for 22 years and without finding a solution. And that is why I think we should keep the petition open, and I would like to help to find a solution to it.
Thank you very much. Now we start the second round. So now has the floor Mr. Yar of EPP.
Usually it could be a good story, a positive story. We could say that the petitioner is right and that has won the case. But, we can see the date here, 1998. This has been lasting for far too long. This shouldn't be the case. There has been a decision in favour of the petitioner, but the petitioner is still waiting. So there has to be something wrong here, of course. But this is a question for all of us, really. What's going to happen? Are we going to wait another 20 years? Then there won't be any more petitioners. So I think that this needs to be looked at again. I think we just can't have it in this way. It's not acceptable. I would say there should be an urgent letter written to the authorities saying that, this is simply not acceptable. You can't handle the rule of law in this way.
Now, to conclude, the petitioner has 2 minutes to conclude. Thank you very much.
Thank you, Madam Chair. First of all, I would like to take issue with the terminology used by the Commission, Mrs. Alessia. She describes the decree law last page as a waiver. I have it on authority from learned counsel in the United Kingdom and also senior lawyers in Italy that this does not constitute a waiver. It constitutes coercion. It is a threat. Now, to give you an example, I have here in my hand the accountant's figures for one of my colleagues, and she is suing for 20 years back pay of 289,000. Is she supposed to simply say, I'm not interested in that, in order to sign a contract for the future which will bring her about 20,000? In addition, I would like to point out that on the 21st of July, the Commission received a letter from the University of Bologna, one of the worst offenders towards the lettori. And in the last page of that letter, I will paraphrase, it says, the decree law changes nothing, either from a legal perspective or financially. And in any case, the decree law does not oblige the universities to start negotiating for a supplementary contract. So the point of view of the university is they would have to co-fund this agreement, and they're not going to do it. There's a very small carrot and there's no stick. Finally, I would like to address and thank Mr. Perez, who has followed this case for quite a while, and I tend to agree with him that there is a huge problem in finding a satisfactory way of calculating things, and perhaps the Commission would like to work on that. Thank you very much.
So basically, the idea would be to keep this petition open. As many others have said, there's a problem of justice, and as the European Commission too has also mentioned, and 2 years have gone by and the problem still exists. So at all events, our proposal would be to keep it open, but we would also send the petition to the URI committee for the application of the EU law, and we'd like to ask the European Commission, we'll ask the commissioners responsible for applying the treaties and the rule of law of the Union and so that they can inform us about this petition. Actually, not inform us, they've got to execute this ruling, and they really have to work with the Italian authorities to solve this problem that's been ongoing for many years. Furthermore, we'll also write a letter to the Italian authorities informing them of this petition. Things have been going on for about 20 years, and at this point, we expect it to be respected, and the ruling has to be carried out. Okay, we'll move on.